So good morning, everybody. So good to see you all. I am Ari. I am the Technical Assistance and Survivor Services Coordinator here at Iowa CASA. I will not be presenting today. I'm here as tech support for the Sansi Kingery, and I'll go ahead and let Sansi introduce herself.
Good morning, everyone. My name is Sansi Kingery. I am the staff attorney at Iowa CASA. I have been here for approximately, a little over 5.5 years in the position as a staff attorney. And I will be presenting today on termination of parental rights with a little bit of focus on the grounds for termination in domestic violence and sexual abuse situations.
And this is Ari. So we can go to the next slide, Sansi. And so just so everyone's aware, we do have interpretation available today. If you would like Spanish interpretation, please go on to the bottom bar. You'll find a button that says interpretation, and then you get to choose English or Spanish and make your preference based on that. And next slide as well. We also have ASL interpretation. So please go ahead to that same interpretation bar and select American Sign Language. So just being mindful of our speaking to make sure interpreters have enough time to interpret well. So with that, we also have a statement on AI note.
To Zoom. Enter your meeting ID.
We also have a statement on AI and AI note takers. So to encourage participation and uphold privacy, we will not admit any AI note takers for the duration of this training, as they may make people uncomfortable and can produce inaccurate or misleading information. If there's an accessibility need for captions, please let me know in the chat and I can enable them. Live captions are not transcripts and will disappear. And disclaimer as well, this training is for educational purposes only. It should not be intended as legal advice or taken as legal advice. So making sure that we're aware of that as well. And again, as I am tech support, please message me if there's any issues with interpretation or audio, and as well as questions, feel free to put them in the chat.
All right, I will take over from here. Thank you, Ari. As Ari said, if you have questions, please put them in the chat. I will try to pause a few times during the presentation to answer questions, mostly as they come up, but it might be a little bit of a pause before you get your question answered. So we are, like I said, going over today the law in Iowa on termination of parental rights. We'll talk a little bit more, some background information to start off the presentation on what it means to have parental rights, what it means to establish parental rights. You should hopefully leave this training, the CE, with a better understanding of what parental rights are and how they're established and how they can be terminated, especially in cases where there could be sexual abuse and/or domestic violence. We're going to just start off, like I said, with a little bit of background. There are some important words and phrases that will be helpful to know as we go through this meeting. The first one is a little bit of a weird one. Putative father. Basically, that is by a male who is suspected to be the biological father of a child. There are certain proceedings such as adoption or termination of parental rights on a mother, name changes, where the law requires that a putative father receive notice of those proceedings. If there are multiple putative fathers, they all have to receive notice. And if you don't know where the putative father is, or he can't be located, or you don't know who he is, notice in those situations can be given through alternative means of service, such as publishing in the newspaper. The second term is a guardian ad litem, or a GAL. That a guardian ad litem is appointed typically by the court in a variety of different cases, including parental termination cases, adoptions, sometimes in divorces. And a GAL is intended to act independently of any other parties to represent the child's best interests and will express those interests to the court. This is a separate role than the attorney for the child, who is there to represent the child's legal interests. Sometimes those interests align and sometimes they do not. So that is why those roles are those roles are separated into two different people. The next phrase that it might be important to know is a best interest of the child determination. This determination is made by the court in every termination of parental rights case, whether that is in a child in need of service, or also known as a China case, or in a private termination proceeding under Chapter 600A, which is what we'll be talking about today. This is one of those things where sometimes what the general public, our parent or grandparent, might believe is in the best interest of a child is going to differ a lot from what the court sees as the best interests of the child. Simply being a bad parent or even a harmful parent is not always enough for the court to determine that it is in the best interest of a child to have the parental rights terminated. The court is supposed to give primary consideration to the child's safety and basically their long-term well-being and health. So the phrase parental rights gets used a lot, and there are always different ideas of what that means, and that's fine. We will use that phrase in this presentation at times, and so I just want to make sure that we have a mutual understanding of what is meant when we talk about parental rights. Under Iowa law, it is presumed that both parents, when they are legally established, have equal rights to the child, as well as obligations to that child. There are no rights without also being obligations to the child. Legal custody is another phrase that is often used to express or talk about the parental rights that parents have. Parents who have legal custody also have parental rights to the child. And legal custody or parental rights can be sometimes limited for certain reasons. Some of the parental rights and obligations, some of parental rights are the right to make decisions on medical care or how the child is educated, whether or not the child is baptized or attends some sort of religious instruction. And then those obligations for a parent include financially supporting a child, and then the obligation to provide health insurance. So the important question is, how are parental rights established in Iowa? Because if we're talking about terminating parental rights, we have to first make sure that we understand how those rights are established in Iowa. There are a few different ways to establish parental rights in Iowa. They kind of fall into two categories: rights, or when the parents are married, and when the parents are not married. Children born while parents are married, or while two people are married, are presumed to be the biological child of the husband. And obviously we're talking about heterosexual relationships here. I don't know if the court has taken on how this is done, in same-sex or in vitro sort of situations. I'm sure there is case law on that, but that is outside the scope, I think, of what we are talking about today. If a child is born, let's say J and K are married, and K gives birth to a child named CC, J is automatically assumed to be the father of CC, and so he would have the right to make decisions about CC's medical care, about CC's religious education, where CC will go to school. He would also have the obligation to provide certain things to CC. If it was later discovered or suspected that J was not the biological father of CC, then that would require a court proceeding to disestablish his paternity. So he would need, or K could file something in court to disestablish him as the father. And that would mean all of those rights and all of those obligations that J had up to that point would be terminated as well. When the parents are unmarried, paternity can be established a few different ways. I'm sorry, I just lost the ASL interpreter, so I want to make sure they.
We're good to go.
Okay, thank you. Sorry about that. So when parents are unmarried, there's a few different ways that paternity can be established. One is by both parents signing a paternity affidavit. An affidavit is a sworn statement that you basically, when you sign it, you are ensuring to the court or assuring the court that you are not lying. This paternity affidavit is signed by both parents. It's usually done at the hospital when the child is born, but it can be done later. The other way paternity can be established when the parties or the parents are not married, and these are the most common ways, are through a judicial or administrative process. So when, if Child Support Recovery Unit or whatever it's called, the state organization or agency that pursues child support, if they want to pursue child support from a parent, they can administratively establish somebody as the parent by ordering a DNA test. Same thing goes in a court case where the judge can order that there be a DNA test performed to establish paternity in a court case. Now, a court case could be to establish paternity. It could be for establishing visitation and custody and support. And then the court would order that a DNA test be done and make a finding then based on those results that the putative father is or is not the actual biological father. The parties can also stipulate or agree in a case that J, I'm just going to use J because I've already used that J is the father, and then the court may just accept that agreement as that J is the father and enter an order saying that. Now, some folks will come to me and say that, well, I put him on the birth certificate, so now he's saying he should get visitation with my child. Birth certificate in Iowa, it's a common misconception that naming someone as a father on the birth certificate establishes him as the legal father. And while that might be used as evidence in a proceeding later on to establish him as the father, it's not enough on its own. There still needs to be a court order or an administrative finding or an affidavit to legally establish the father. And obviously this is in a situation where the parents are not married. Similarly, there is a form that a man who suspects himself to be the father of a child can fill out. It's called a declaration of paternity. And he fills that out and he submits it and keeps it on file with the Bureau of Vital Statistics in Iowa. That is also not enough on its own to legally establish him as the father. But again, it can be used potentially as evidence in a later proceeding to establish him as the father. So just to wrap up this section real quick, some key takeaways. When parents are unmarried, something has to happen in order to legally establish the father as the legal parent. You can't necessarily terminate parental rights until they have been established legally or there has been a request to establish parental rights. And until paternity is established, no legal rights or obligations to the child exist. And so if you have any questions on that section, feel free to put them in the chat and I will thank you, Ari. And I will answer those. But we can also move on to sort of the next section, which is going to talk about terminating parental rights sort of in general. So now that we've talked about how parental rights can be established, how can those parental rights be taken away? And again, there's a few different ways. The one that a lot of people might be familiar with is a child in need of assistance or a China case. That sort of case can be brought against either parent and is usually brought in cases of abuse or neglect of the child. The other way that parental rights can be taken away is through a private petition to terminate parental rights, which is Chapter 600A, which is what we will be talking about today. And it is important to know and be aware that when we're talking about parental rights, that those are not rights that the courts feel great about taking away from people. It takes a lot of evidence and a lot to convince a court to take away someone's parental rights. Iowa law says that parents do have a constitutional right to their children. And so, right or wrong, the law says that in general, it is in the best interest of a child to have continuing contact with both parents. This approach can often feel contrary to what a non-abusive or non-neglectful parent or somebody else who cares for the child believes is in the best interest of that child. So, just to illustrate how seriously courts take terminating parental rights, it's not unheard of for a court to order a child to still visit an incarcerated parent, even if that parent is incarcerated for domestic abuse, the other parent or another child of the home, or of a serious crime not committed against the child or the other parent, but still a very, could be a very serious crime like murder. TPR, or termination of parental rights cases, especially when in a China case, are some of the most commonly appealed cases in the judicial system and are very closely scrutinized by courts to ensure every step along the way, every procedural step, and everything has been done to help that parent maintain their parental rights. Like I said, there are two ways to terminate parental rights. One is a child in need of assistance, which involves the state, usually DHS or HHS, prosecutor, and that is initiated by a removal of the child and a court order, a court decision that says that that child is in need of assistance because of abuse or neglect that is going on in the home. And then what we're going to focus on today is the private termination of parental rights under Chapter 600A. And under that chapter, a petition for termination of parental rights can be filed by different people. It's not only filed by DHS. It's not filed by DHS or the court or a prosecutor. It's usually filed by a parent or a potential parent, such as a step parent adoption, It can also be filed by the legal guardian or the legal custodian of the child who isn't necessarily a parent. It's going to be filed, in the county where that guardian or custodian or biological parent is living. And there are certain things that has to be included in the petition. A petition is just the document that gets the case started. That's what is filed with the court to say, hey, court, I want this sort of case. I want you to look at this. There are always, depending on the petition that you file or the case that is being started, there are always rules about what has to be in that petition. But it has to set forth enough information to let the court know what sort of case is being filed, who the parties are that are involved, and what the requested remedy or the requested outcome is. If there is a safety concern for the child or for the biological or for the parent or person who is filing the petition to terminate parental rights, the address for the child and the petitioner can be kept confidential. So after the petition has been filed, the court so now a petition has been filed. So that starts the case. That gives a case number. It gets it in front of a judge. It starts a docket on the electronic filing system. And now the next step is that the people who are involved in that, going to be involved in that process, who are in the code are referred to as necessary parties. Those people have to receive notice. And these necessary parties are people who have been involved in the care or would be involved in the care of the child, who were named in the petition that was filed. So that includes any other guardians. It includes all putative fathers who have filed a declaration of paternity, and any and all unknown putative fathers as well. There are some exclusions that are relevant to sexual abuse circumstances. If the biological parent has been convicted of sexually abusing the other biological parent, then, and that sexual abuse produced the child, then that person does not have to receive notice for this sort of proceeding. Before this notice is served on all those parties, the court will likely appoint a guardian ad litem or a GAL. A GAL is necessary if there's no guardian for the child, or if the guardian's interests are going to conflict or might conflict with the child's interests. And often, the court may not know that until later on in the proceeding. So what commonly happens in my experience is that the court will appoint a GAL at the beginning to make sure that that person is there from the very beginning of the case and make sure that the child's best interests are being presented to the court by an independent person. The notice has to include certain information. Obviously, you have to, if you are going to have your rights terminated, you need to know the time and place of that hearing to do that. You need to know why that hearing is happening. And then it would be important for that person to also know that they have the right to an attorney. That doesn't necessarily mean that they would have the right to a court-appointed attorney, but they could if they could show to the court that they were that they met the financial guidelines, that they were indigent. So what happens to those when you have to give notice to unknown putative fathers or people who you don't know where they are right now? That happens a lot in termination cases, and so the law doesn't mean that that the whole case stops. You can still serve that person by publication through the newspaper, which there are lots of rules on that about how long that notice has to be in the paper, what sort of paper it has to be in, like how the reach of that paper. It can't be like a little teeny tiny like college newspaper. It has to be a newspaper of general circulation. So like even a small town newspaper is usually good enough. But anyway, there are ways to get around if somebody doesn't know who the father is or where the father is located, or any of those other people who have to receive notice. Any questions on that so far? Go ahead and drop them in the chat. I'll be happy to answer those questions as we move forward. So just some other random provisions of this chapter to keep in mind. Like I said, parents have the right to counsel. There is a provision that allows for the payment of attorney's fees in certain situations. And then there's a provision that talks about payment of GAL fees, or guardian ad litem fees. The guardian ad litem is entitled to payment. And that's one of the things that I talk to people about when they do come to me for to talk about a divorce or terminating parental rights or child custody or any of those cases, is that the likelihood of a GAL being appointed is pretty high in any of those cases. And they need to be prepared to either ask the court to waive payment of those fees for the GAL and prove to the court that they're indigent, or they need to make sure that they have the funds to pay for the GAL, because sometimes the GAL may not start their work until they have been paid. And if the court orders you to pay the guardian ad litem fees and you don't do it, then that could result in a contempt action or some other sort of sanctions against that parent. So some of the grounds under Iowa, the chapter 600A.8, this is the section that lists out all of the grounds for termination of parental rights in Iowa. The first one is a release of custody. And so that is when the parent just signs a document, like not some random document. It's a document that has to say certain things, that they understand the meaning of what it means to have their rights terminated. And then they would sign that release of custody, and that could be filed with the courts. The court may still require that person or require some sort of hearing to occur so that there could be a record made that that person understands what it is that they're doing and the effect of releasing their custody. This can often happen I've seen this be a potential happening in cases where there is a step parent willing to adopt, or there is a parent who maybe they're still competent to sign the release, but maybe they have long-term severe mental health issues, or they're going to prison for life, and there's somebody else who might want to, be a parent to that child. The other provision that is really used a lot is abandonment of the child. And I'm not going to go into a ton of detail in this presentation of what it takes to prove abandonment, but it is important to know that not paying child support is not enough to show abandonment. The parent really has to give up on the child. And to prove that, the parent asking for the rights to be terminated has to show that that other parent has had the opportunity to participate in visitation, to support the child, to have time with the child, to be a parent to that child, and has not taken advantage of those opportunities. So in a situation where a parent maybe, has some mental health issues and has not been able to be with the child or visit the child for a while, and the one parent comes talks to me and is like, there's another parent, my new spouse wants to adopt my child, but we would have to terminate the other person's rights first. He hasn't seen the child for a year because he's been, he has severe mental health issues, but he calls every once in a while, but he doesn't pay consistently child support. That might not be enough to show abandonment, because the parent who has that severe mental health issue may not be willfully not engaging with that child. Their lack of engagement may be because of their mental health issues. And so the fact that that parent still reaches out every once in a while to get updates, again, that could be a situation where a court looks at that situation and says, well, it's not that person's fault that they are not consistently showing up. We're still going to give them a chance. So if that person whose rights are at risk of being terminated can show good cause or good reason for not for not taking advantage of visitation or paying child support, such as being incarcerated or having a disability, an extended illness or injury, extended unemployment, homelessness, any of those things, the court may not see that as abandonment of the child, because those things may not be considered willful. So just not following the visitation schedule fully is not enough to establish that that other parent has abandoned the child. Now that I've said that, not paying child support without good cause is grounds for termination. So like I said earlier, once your parental rights are established, once legal paternity has been established, that means that you have parental rights and obligations to that child. One of those obligations is to support that child, and that is usually done through paying child support. If a parent has the ability to pay child support and doesn't, then that could be grounds for termination. So if you have a parent who has a job, makes good money, makes enough to pay the child support amount that has been ordered, and to do that every month, and has not paid child support consistently or at all, doesn't intend to start paying child support for some reason in the future, just doesn't want anything to have, anything to do with that child and supporting them, then that could be grounds for termination. One thing we will talk a little bit about later is the courts will consider in this sort of situation, if that parent's rights are terminated, one, that means that any future obligation for child support goes away, but past child support does not. So there may still be a way to get that person to pay some of the child support that they do owe. There may be ways still to force that parent to pay something, like going after their tax return or something like that. Usually there's wage garnishment that can be done. But if for some reason that can't be done and they're just not paying support, then that can be grounds for termination. The second two grounds for termination, the parent not objecting after they've received notice, and then they're not objecting after all reasonable efforts have been made to identify and locate them. Those are examples of why it's really important to give proper notice to all of those people who need to be given notice, especially any potential or putative father who could come back later on and say, well, I didn't know about this. I would like to have a relationship of this child, and that can throw a wrench into things for that child and for their other parent. The court may, in these situations, require that a little bit more effort be made to locate and provide notice to that parent, just to make sure all of those routes to get that person noticed have been explored. That can be frustrating sometimes to people who just want this process to be over with. They're like, this person hasn't been around, we don't even know who they are, but now we've tried to get them noticed, and now the court's making me do it again, or making it go on longer. I don't understand why they're doing that. Well, the judge is doing that to make sure that we've done everything that we can so that other person gets noticed and has an opportunity to be heard if they want to be. But it is also a protective measure for the child and for the parent who isn't having their rights terminated. Because, if there is a putative father out there, or potential parent out there, and they don't receive notice and they find later on that their rights have been terminated, they can come back and they can, try to appeal that decision. There are time limitations on that, but regardless, it can throw a wrench into everything. And if that child has had a family reestablished after termination of those rights, and now somebody else shows up and is trying to get rights to that child, to see that child, that can sort of trickle down to that child and have a negative effect on that child's well-being. So the court really does not want to see that happen, and may order additional efforts being made to notify that parent just in case that decision is appealed. Iowa does not right now have a statute that would allow for reinstatement of legal rights once they are terminated. But like I said, termination of parental rights can be appealed. If termination of parental rights, or TPR, is granted, the parent whose rights have been terminated can apply to either vacate or appeal that order within 30 days. So again, that's why giving proper notice is really important, because it prevents confusion and uncertainty for everybody involved, but especially for that child. And then again, step-parent adoption is also a really common ground for termination of parental rights. So this is where, mom has remarried and there is another parent who wants to adopt that child, but the other biological parent's rights need to be terminated. I say mother, but it could be the other way as well. Just a step-parent adoption in general. But like if the law allows, if that adoptive parent later finds out that adoption was fraudulently induced, or there was some sort of lie that occurred to get that person to adopt the child, they can file to terminate their own rights, so that they then no longer have any rights or obligations to that child. And then there are a few grounds for termination that are directly related to domestic or sexual abuse. So we will go over those next. I just want to pause again to see if anybody has any questions on anything that we have talked about so far. Okay, doesn't look like there's any questions in the chat, so I will keep moving on. So the first ground in chapter 600A that is related to domestic or sexual abuse, termination of parental rights. This one, both of these elements have to apply, and we'll go a little bit further into those here in a little bit. But if Okay, I'm going to pause real quick because there is a question, and I think it goes back to earlier in the presentation. So the question was asked in the chat, if a parent has sole custody, what does the other parent have, and how does that parent get joint custody? So when we talk about custody, we are talking about two types of custody. We're talking about legal custody or parental rights, and we're talking about physical custody or physical care, physical custodianship of the child. So if a parent has sole physical care or sole physical custody, that doesn't necessarily, so I'll go back to K and J for a second because they are an established couple in this presentation. So let's say K has sole custody of Cece and J sole physical care of Cece. So that means that Cece is with K basically 100% of the time. K is the primary caretaker. J may have short periods of visitation. That visitation may be supervised. That is usually done in a situation where, say, J had been absent for the child's life for a time period for whatever reason. And this is an opportunity for the child to get to know J. It could also happen if the child has been removed in a China case or has been determined to be a child in need of assistance because J is suspected of committing abuse or neglect against Cece. And so K has sole physical care of Cece. That would not necessarily mean though that J doesn't have any legal rights to Cece. J could still have the right to make certain decisions, about Cece's schooling or healthcare, or at least have the right to be told about those decisions and be potentially involved in that decision-making process. If what we're talking about, and so if J wanted joint physical care, there is likely a court order somewhere that says what he needs to do in order to get joint physical care. So basically to either have visitation reinstated or to have, sometimes you hear about 50-50 custody and that or shared physical custody. And so that is a 50-50 arrangement where the parents truly do equally or about equally split time with the child. So in order then for J to get joint physical care of Cece, he needs to do whatever the court is telling him to do, or DHS is telling him to do if it's a China case. Usually, just speaking on my experience, that involves J going to therapy. That usually involves J, undergoing a mental health and or substance abuse evaluation and following the treatment recommendations that result from that evaluation. It might involve J submitting to drug tests regularly, J taking advantage of the visitation that he does get and cooperating with, the worker in whatever the worker says. Usually there's a report when there's supervised visitation where the person who's supervising it can come to the court or the GAL and report back what they're seeing. So J would need to demonstrate in those supervised visitations that he is able to parent the child to the extent that he is able to parent that child in what is probably a few hours visitation. So he has to show appropriate interactions with the child, ability to appropriately discipline the child, feed Cece, take Cece to the bathroom, all those things that parents do. And then the DHS worker or whomever will make a report to the court and the court can decide based on that evidence whether or not Jay has done enough to get joint physical custody. And that's usually like an escalating process where he'll start out with supervised visitations that are a few hours, and then he might start off with a few hours or afternoon of non-supervised visitation, and then he'll go to overnights, and then it'll just sort of work its way up until Jay has reached sort of the maximum amount of visitation that he can have with Cece. If we're talking about sole legal custody, then that would mean that Jay has no right to make any decisions for Cece or on Cece's behalf. So Kay would be the only decision maker and would decide where Cece goes to school, Cece's medical care, all of those things. That doesn't necessarily mean Jay doesn't get notice of those things. The court may still order, because if Jay is still in the child's life, that Jay should get notification of, say, if Cece has a doctor's appointment or was sick and went to the hospital, things like that. And then again, in order for Jay to get joint legal custody or joint legal care back, or to get that for the first time, depending on the circumstances, he needs to do what the court tells him to do. And again, that is usually a lot of the same things that I listed off before. Mental health or substance abuse evaluation, following through with the recommendations of that evaluation. Just basically an ability to show that it is in the best interest of the child to have Jay as a co-decision maker with Kay for Cece. So if there was something there that part of that question or part of something, Amanda, that you asked that I didn't answer, please feel free to leave a follow-up question in the chat. But I will, now we'll go back to this first ground for termination in 600A. So during this section, you might hear me use the phrase the parent or offending parent. That means the parent who is having their rights terminated. I may also use the phrase petitioning parent. That is the parent who is asking for the rights to be terminated. So just a little note on language there. So this first ground requires that the parent whose rights are being terminated have a substance use disorder and has committed 2 or more domestic abuse assaults. And also that that parent has abducted the child or improperly removed the child from the physical custody of someone else who was entitled to custody without that person's consent. Or that that parent has kept the child after a visit when they should not have. And so going back to J and K, let's say J has, oops, sorry, it's too early. So let's say Kay comes to me and she wants to know what she can do because J has a substance use issue, and she is worried and wants maybe to terminate Jay's parental rights, but the child hasn't been removed and there's not a China case pending. So we would talk about, because she mentioned substance abuse disorder, we would talk about what that means. Under Iowa law, that means that there's a specific definition that applies to that, that I won't bore you with, but basically what has to happen likely is that there would need to be some sort of evaluation, treatment, and formal diagnosis of that disorder, of that substance abuse disorder, for this first half of this first element to be met. Yeah, as the petitioning parent, K would have to produce evidence at court that shows that J has a substance use disorder. Now, if J has been convicted of substance abuse offenses in the past, or there has been it has otherwise been established that J has a substance abuse disorder, then K can bring in evidence from those other cases to show that he has that. If not, K may need to ask the court to order J to undergo substance abuse evaluation for the purposes of this termination of parental rights proceeding, and then hope that that comes back showing that he has a substance use disorder. Because if he doesn't, then this ground is not going to apply, and she's not going to be able to terminate his parental rights based on this ground for termination. And then the second half of that first element is that that he has committed 2 or more domestic abuse assaults. So I think most people are familiar with the definition of domestic abuse assault. It's the one in 708, chapter 708. It's the one that applies to all domestic abuse criminal cases and civil POs. There's like a special relationship plus an assault. So household members, intimate partners, parents of the same minor child, and some sort of usually physical assault or imminent physical assault, where the non-abusive parent fears that for their physical safety. Both of those elements have to be met for this first piece to be met. And then the other big element that has to be met in here is that J has abducted the child or improperly removed CC or improperly retained CC after a visit. Abducted is not defined in this chapter, but probably what that means, I didn't get a chance to do the case law research on this, but the court would look at if it meets the definition of kidnapping in Iowa law in order to make a determination whether J had abducted CC or not. And so both of these elements, again, have to apply in order for this ground to be met and for K to successfully ask the court to terminate J's rights on this ground. I do want to go back just real quick. So this says remove the child from the physical custody of someone entitled to custody. So in a situation where, let's say, K does not have physical care of CC, let's say the child has been removed from K's care as well, or K is out of the picture for some reason, but there is a guardian who has been established under the guardianship laws. The J cannot then remove CC from that care of that physical of that guardian, because that person has the legal right to care for CC. So just because that person isn't K, isn't the other parent, that doesn't mean that J automatically, his whatever rights he may have left or whatever interest he has still in CC doesn't trump that person, that guardian's rights. So let's say there's a guardian, you know, K's mom is a guardian, and J removes CC from grandma's care without permission. That could meet this ground. That could meet this ground for termination. All right. So the second domestic or sexual abuse related ground for termination of parental rights is in subsection 9 of this chapter. And this again, this has 2 possible routes to do this one. A parent has to be imprisoned for a crime against that child, the child's sibling, or another child in the household, or that parent has been imprisoned and is unlikely to be released for 5 or more years. Excuse me. So for this ground to be met, it's not enough for, again, Jay, he's having a rough day today, for Jay to have harmed or committed a crime against a child. It has to be the child to whom his rights are being, to CC or CC's sibling, or another child in the house. Let's say CC has a half sibling, or Kay has guardianship over her niece. That's another child in the household. So if Jay has committed a crime and has been imprisoned for that crime against CC or CC's sister or another child in the household, that could be a ground for Kay to terminate Jay's parental rights to CC. Or let's say Jay has been imprisoned for some reason and is unlikely to be released for 5 or more years. So this is this would mean that Jay had been convicted of a pretty serious offense, a felony, and is now imprisoned for the next 5 or more years. In that situation, the court may see that it is in the best interests for his rights to be terminated to CC. But again, the court has to still consider whether or not, even if this, and we'll talk a little bit more about this on kind of springing this on you, if even if this ground is met and Jay is going to be in prison for 5 or more years, the court still has to determine whether or not terminating his rights is in CC's best interest. So there's sort of a 2-part test, and I'll talk a little bit more about that. But just him being imprisoned with a sentence of 5 or more years of imprisonment would be enough for Kay to ask the court to terminate his rights. Now, one of the questions I had, and if Kay came to me and was like, Jay's been imprisoned, he's not going to get out for 7 years, I want to terminate his rights because, I'm going to get remarried and CC loves my new partner, whatever. I would talk to her about what it means for Jay, what it means to be imprisoned. One of the questions I would have, sentencing in Iowa is really weird. It's possible for someone to get sentenced to a really long prison sentence, but actually only serve, a few years of it for whatever reason. From the research that I did preparing for this, the law for this section, when the word imprisoned is used, does mean imprisoned or some sort of restraint in a prison or residential facility, and possibly even time in jail. And so if, Jay was then, got out, but went to some sort of residential treatment program and where he had to be, then that could, as part of his sentence, then that still would potentially count as time that he was imprisoned. So that would be something important to know if Kay were to come to me and wanted to talk about this ground of terminating Jay's rights. All right, so the next one, is not fun to talk about, but this is where we're looking at a ground to terminate rights because the parent has committed a sex offense against a minor. And this too, this might be one of the first ones where I have seen in my experience also can often apply to mothers, the biological female parent who have committed a sex offense against a minor, and now the father is asking for her rights to be terminated. But under this provision, we'll look a little bit closer at it. Switch slides real quick, sorry. So the first part in this section is that the parent whose rights are being terminated has to have been convicted of a felony sex offense against a minor. Iowa law defines sex offense against a minor as conviction of a tier 1, tier 2, or tier 3 offense, which is all the tiers in Iowa. So any sex offense against, potentially any sex offense against a minor, that would require registration on the sexual offender registry. Those include SA1, sexual abuse 1, 2, or 3, lascivious acts with a child, certain grooming, assault with intent to commit sexual abuse, and continuous sexual abuse of a child. Felonies in Iowa range from a class A to a class D, from most to least serious. And so if a parent is convicted of, if K, let's say in this situation, was convicted of sexual abuse in the second degree of a minor doesn't have to be CC, then Jay could potentially come to me and say, I want to terminate Kay's rights because she has been convicted of a felony sex offense against a minor. So all of this, the conviction of a felony offense that is also a sexual offense, and the victim was a minor, all of this is needed for this first bullet point, this first element in this section to be met. And then you also have to have show that the parent who is having their rights terminated, well, I guess the parents were never married or have been divorced from the minor's other parent. You know, one situation I see come up when people come to me for a variety of reasons is the potential of a common law marriage. And so I want to just address that real quick. Somebody might come to me and say, well, I want to terminate their, Jay's parental rights, but we've been together for 8 years. And does that mean that we are, and I've been told that that means we're common law married. So does that mean that I don't, that this ground wouldn't apply to me? And the answer to that is, I don't know. Unfortunately, I couldn't find an answer in the case law on this one. But just, for reference, 7 years is not like some magic number. In Iowa, you have to, in order to establish common law marriage, you have to show that the parties held themselves out as the law says husband and wife. So that means calling each other husband, wife, putting people on your life insurance, health insurance, filing taxes together, that sort of thing. But if there is a common law marriage in one of these situations, it does have to be ended through divorce. So if there's a possibility of a common law marriage, we would want to talk about the safest route to go if they wanted to pursue this ground for termination, but also talk about that there might be easier ways to accomplish what they want, because that's an extra step that can take a lot of time to go through. And then the final element for this ground is that the parent whose rights are being terminated is serving a minimum sentence of at least 5 years for the offense that is the sexual offense felony. So that would, for the most part, rule out class D felonies, because those generally are not, you can't be confined for more than 5 years, but it still leaves, class A, B, and C felonies on the table. So if somebody was convicted of one of those things and was sentenced to 5 years for that, then that could potentially be enough to terminate their rights on this ground. The other thing that I would talk to someone about if they came to me and wanted to talk about this is, well, they're in the process of filing for divorce. They're in the middle of it. And so can she just go ahead and file right now to terminate? The answer is no. It says you have to be divorced. So unfortunately, you would have to wait until that divorce was finalized. And then you would want to wait until after the appeal deadline had passed to file this action. All right, so example 1. Again, this would be, let's say, K in this example again is the non-offending parent, and she has 2 children together with J, and the children's names are B and D. Last month, K requested a civil protective order against J on behalf of B and D. At the hearing, the judge heard evidence and made a finding that J had sexually abused B and had abused D, resulting in severe injuries. All abuse was reported to police, and now J has been charged with Class C felony of child endangerment. So just looking at this example, there's a few issues if this set of facts was brought to me by a parent. This would basically not meet this ground, right? Because Jay has not been convicted. I don't know if the parents were married or not. I would tell Kay that she would need to come back once Jay has been sentenced to see what that sentence is and what he's actually convicted of. Because even though he's been charged with something that would qualify under this section, doesn't mean that that's what he's going to be convicted on. But I would talk to Kay too about some of the rights that she would have, and some of the things that she could do to set herself up for success if this is where she wanted to end up. So if she came to me, those are some of the things that I would do, even though this doesn't count. This would not be an option for Kay at this time. So this is the one I get a lot of questions about. And this is when a child has been conceived through a sexual assault, and now the birthing parent wants to terminate or prevent the other parent from getting their parental rights established. I first want to note that I did research this section. I looked at case law and I tried to find a case that fully analyzed this section. And unfortunately, I could not find any appellate cases. Attorneys turn to appellate cases because the Court of Appeals or the Supreme Court will go through every element and talk about the evidence that applies to that element. And it gives you generally a really good analysis and gives you generally a good idea of how a court would interpret this section. And so it's really helpful to have appellate cases. Unfortunately, I could not find an appellate case on this section. So I have tried to interpret it to the best of my ability, keeping in mind that a court can always analyze any given case differently. So I just want to give that sort of disclaimer right now. And I'm happy to answer questions in a little bit, but please be aware that I will be answering them based on what my experience suggests, and there are no, unfortunately, really clear answers on this one. So the first part of this is the court has to find that there is clear and convincing evidence. Clear and convincing evidence is a standard of proof. A standard of proof is the amount of evidence that is needed to prove a case. You've probably all heard of beyond a reasonable doubt. That is the standard of proof that applies in a criminal case. In civil protective orders, the standard of proof is a preponderance of the evidence, which is the lower end of standards of proof. And that is a preponderance of evidence just means it is more likely to have happened than to not have happened. So we talk about 50% plus just a little bit of extra weight on it to show that whatever it is you are alleging to have happened probably happened. And so clear and convincing evidence is in the middle. It is less than beyond a reasonable doubt, but more than preponderance of the evidence. And what it just means is the judge has to walk away feeling really confident that they made the right decision, but they could still have doubts. So they do not have to know for certain that something happened, but they need to be pretty darn sure. And so what you would have to prove to that standard of evidence, so what you would have to prove to the judge is that the child was conceived as a result of sexual abuse as defined in 709.1. And so just as a refresher, that definition of sexual abuse in 709.1 is a sex act that is either by force or against someone's will, or a sex act and the other person is suffering from a mental defect or some incapacity that prevents them from giving consent. Or lastly, when the other person is a child, which is 13 years or younger. The key word, I think, in this section, in this sentence, is that the child has to have been conceived as a result of sexual abuse. So how do you prove that a sexual assault resulted in conception? How do you prove to a judge to the point where they can walk away feeling pretty darn confident that this child was conceived as a result of sexual abuse? And what does that look like in cases where there has been, one or, intermittent, scattered sexual abuse incidents versus one where there has been, more continuous sexual abuse incidents? But not every sexual encounter was sexual abuse. There isn't enough, in my opinion, under this section for there to be intermittent sexual abuse in a relationship. Likely what this would mean in practice, let's say Kay wants to terminate Jay's parental rights based on this ground. So Kay would file a petition and get everything sorted, and now we're at the hearing. Kay would probably have to bring some sort of expert to court and present evidence that a sexual assault that could have resulted in a child being conceived happened during the time frame during which the child may have been conceived. So that means she probably needs an expert witness, like a doctor or a highly licensed nurse in the area of obstetrics, babies, who knows a lot about helping people give birth and working through pregnancies. An expert who's good at that to review medical records and testify that since the child was born on a certain date, that means that the window of time in which that child could have been conceived was, during this time, during these weeks. And then it would be up to Kay to show that during that time frame, there was a sexual abuse that occurred and a sexual abuse that could have resulted in conception of the child. And so again, given the applicable burden of proof, clear and convincing evidence, the judge does not have to walk away knowing on exactly what date that sexual assault incident occurred and know for certain that is the date that the child was conceived. But the judge has to walk away being pretty dang sure, being very convinced that child was conceived as a result of sexual abuse during that time frame. And again, Kay can offer evidence, a variety of evidence to show that sexual abuse occurred. Obviously, her testimony is always evidence, but if there were diary entries, other medical records, a SANE exam, police reports, things like that, that could also be used as evidence. And the biological parent has to request termination. So that this suggests to me that there has to be some sort of DNA evidence presented if paternity is questioned, or if paternity was established through marriage or an affidavit, a paternity affidavit. So another example, Jay has filed an action to establish paternity, visitation, and custody for CC, and Kay has been served. She comes to me and she mentions that wanting to know what her options are, and she comes to me and mentions that in their relationship, Jay was sexually abusive. She does mention, though, that they were never married, and but she says that Jay's name is on the birth certificate and that he's demanding to see CC. So in this situation, this would be a situation where I would need, unfortunately, to know pretty early on what the exact nature of the sexual abuse was that Kay has mentioned. And so that would mean asking her pretty invasive questions early on about when and where and what exactly happened, to make sure that, one, that it fits the definition of sexual abuse, and that it's sexual abuse that could have resulted in conception of a child. Because remember that sexual abuse has to result in conception of that child. And then I would talk to her about if they filed a paternity affidavit. She says they've never been married. So had they filed a paternity affidavit? Or has child support been ordered through either HHS or a court proceeding? Or is that process in process? Is it going through that? If they didn't, because they weren't married, and if there hasn't been a finding of paternity in either a child support case through HHS or a court, then just because Jay is on the birth certificate, remember, he's not the legal father of CC. So, this is a situation where I couldn't necessarily help Kay with this ground for termination right at this moment. But what we could do is talk about ways to keep her and CC safe, because at this point, Jay does not have legal rights to see CC. He has not been legally established as CC's father. So that means he doesn't have any rights to CC. It also means he's not obligated to support her at all. So we would talk about that and talk about a pro-con, sort of weighing the risks and benefits of getting that process started. I would also talk to her about getting a civil protective order to address any immediate safety concerns. And I would talk to her about starting to gather evidence to eventually establish that CC was conceived as a result of sexual assault. So those things that I mentioned a little bit ago, like medical records, photos of injuries, police reports, anything like that. I would also talk to Kay, about public assistance, and if she's planning to sign CC up for any sort of public assistance. This is important to know because courts are hesitant to opt to terminate parental rights, even when there are grounds to do so, if it means the child ends up on some sort of public assistance. Because from the legal standpoint, that is a drain on resources that could maybe go to somebody else when they're, if Jay is able to pay child support, is in a position where he could pay child support, then instead of CC being on public benefits for 18 years or whatever, they're going to look at Jay to support that child. And so through that process, Jay's paternity is going to be established. He's going to be ordered to pay child support, but he could also use that establishment of paternity to then go and petition for visitation and custody. So that again is something where we have to talk about that risk benefit analysis with Kay. I would talk to her about that. And then, like I talked about a few times, just having a ground, establishing a ground for termination of parental rights isn't enough in Iowa. You also have to show that it's in the best interest of the child for those rights to be terminated. If it's not in the best interest of the child, the court could still decide that they're not going to terminate those parental rights. And then the final thing I just kind of want to bring up and keep in mind, and this is something I talk to survivors about a lot, is that we have to remember that we are working with different understandings of the same words and phrases. And when we're talking about termination of parental rights or whatever it is, criminal cases, protective orders, we have to look at what the legal definition is of that word or phrase. And that is almost always going to be different than what collectively our definition is, advocates, my own definition of something, and then the survivor's definition of that word or phrase. And so, especially that comes up a lot in my practice, especially with sexual abuse or sexual assault. There, I think most of us have adopted a pretty broad definition of what sexual assault or sexual abuse is for us to give services or to give help to people. But under the law, it's a much narrower definition. So, for example, under Iowa law, stealthing, which is when a male removes a condom without permission or knowledge from their partner, that's not currently a crime in and of itself. There's been legislation, has it passed? Talk to your legislators. But even if this is so this could be considered by us sexual abuse. I've talked to people where this has been sexual abuse. I had a Title IX case where on this sort of similar sets of facts, the other party, the respondent, was found responsible for a violation and was kicked out of school, but it's not against the law. And so that means it's not sexual abuse. And so it wouldn't necessarily mean what you need to terminate parental rights if a child resulted from that. Now, it could also be, there could be arguments that can be, reproductive abuse, that could be domestic abuse if they were in a relationship, maybe. There might be other ways to show that it was part of a behavior of someone who was controlling or something. And so that could play a part in a court's decision to grant care or custody of a child to somebody. And so I'm going to wrap up now, and we have about 3.5 minutes left. If you have any questions, you can put those in the chat like before. If you have any new referrals, please send those to the legal intake at iowacasa.org email. You could also, I think it's live on our website now, but there is an intake form you can fill out. We are doing that online now. So that's cool and technologically advanced. But if you do have a new referral or request for services, please email that email. It gets a lot less mail than mine, and there's a lot less risk of it getting buried somewhere. Real quick, I don't see any questions yet in the chat. So real quick, I am going to maybe just review our current services. We have flyers that are in Spanish and English. So if you want any of these, let me know. I'll send them to you. But just a reminder, I'm able to provide services, direct legal representation to primary survivors of non-intimate sexual violence who are 11 years old and older. And so a lot of the cases I do are civil protective orders and Title IX cases, but I can also talk to people about family law cases. We do have funding through the Iowa Judicial Branch, IOLTA grant to provide some services to survivors of sexual abuse in an intimate partner relationship. So just be aware of that. It is limited funding, and the bulk of the program is still focused on non-intimate partner sexual abuse. But I can talk to people about a variety of things. And again, if you have somebody you think would benefit from talking to an attorney, please feel free to email the legal intake at iowacasa.org email, and we will go from there.